In our last lesson, we talked about Article 32 of the Civil Code. This provision of the law talks about the first class of independent civil actions, and these cover violations of our constitutional rights. Today, we're taking a look at Article 33 of the Civil Code. This is the second class of independent civil actions, and this provision covers instances of defamation, fraud, and physical injuries. By the end of today's lesson, you should be able to, number 1, explain the rules that bind independent civil actions. 2, state the reasons why we have independent civil actions. 3, enumerate instances where Article 33 of the Civil Code is applicable. All of this and more coming right up. This episode is brought to you by Dekada, 10 life lessons from 10 years in law school. Sa akdang ito ako na ang nagkamali, nadapa, lumuha at nasaktan para ikaw kapatid ay makatapos sa loob ng 4 o 6 na taon. Think of it as a game guide, a cheat sheet that you can use throughout your law school journey. By purchasing this ebook, you are sowing the seeds of free legal aid for those who fall within the gaps of the law. With your help, we can bring the law to the people and more people to the law. Grab your copy through the link in the description down below. Hi, my name is Lex and welcome to Lex in Motion. In this channel, I'll be helping you build your competence, confidence, and capability in law school. Start today by hitting the subscribe button below. New episodes are posted every Friday. Article 33 of the Civil Code provides that in cases of defamation, fraud, and physical injuries, a civil action for damages entirely separate and distinct from the criminal action may be brought by the injured party. Such civil action shall proceed independently of the criminal prosecution and shall require only a preponderance of evidence. There are a lot of new concepts here, kapatid, and I want to walk you through each and every one of them. Bago sa ating pandinig, syempre ang mga konsepto ng defamation, fraud at physical injuries. Dadaanin natin yan, kapatid, huwag kang mag-alala. Dahan-dahan lang tayo. Naiiba ang Article 33, kapatid, dahil sa lahat ng uri ng independent civil actions, dito madalas kumuha ng tanong ang ating mga professor. If there's going to be a question on your exam on independent civil actions, trust that it's not going to come from Article 32, but instead it's going to come from Article 33. So please listen carefully. I would like to begin tonight's discussion with the rules concerning independent civil actions. As I've mentioned in the past few episodes, an independent civil action is a civil action that arises from any other source of obligation except from a crime or felony. They may be filed at any time even when there is a pending criminal prosecution. Independent civil actions exist on a parallel reality with the criminal prosecution. The acquittal or conviction of the accused in the criminal action has no bearing, no impact on the outcome of the independent civil action. However, there are two important rules that bind them. First, the quantum of evidence required in independent civil actions is mere preponderance of evidence. Second, the injured party cannot in any way, shape, or form recover twice the damages. He or she cannot recover damages in the criminal case and at the same time from the independent civil action. By this time, kapatid, dahil makailang ulit na rin tayo sa konseptong ito, ay sana sa ulado mo na ang rules sa independent civil action. Parallel sila sa main case ng criminal action. Hindi natin kailangan ng reservation para atin silang ma-file. Mas mababa ang quantum of proof required at mere preponderance of evidence lang ay pwede ka nang makakuha ng danyos. However, your right to recover damages is limited to one. Hindi pwede ang double recovery dahil hindi natin pwedeng pagkakitaan ang krimen, aksidente o anumang cause of action natin sa ilalim ng ating batas. Why do we have independent civil actions? Hindi ba mas practical, sir, na iisang kaso na lang natin pag-usapan ng liability ng defendant o ng accused? Hindi po ba mas simple na lang kung sa iisang kaso na lang at hindi na masasayang ang oras ng ating mga judge? Justice Paras makes a very solid point on why we have independent civil actions. Kung Kung iyong mapapansin kapatid, Article 32 involves our constitutional rights. 33 talks about fraud, defamation, and physical injuries. And 34 covers the failure of police officers to render aid. All of these provisions touch on the very delicate relationship between two different agencies in the executive branch of government. First, we have the National Prosecutorial Service, which is an attached agency of the Department of Justice. The second is the National Police Commission. The first agency is tasked with pursuing violations of the law. The second is tasked with enforcing the law. From time to time, their duties and responsibilities will overlap. Prosecutors have to work closely with police investigators. If the person charged under Article 32 is a police officer who has violated one, some, or all of our constitutional rights, then it's very possible that the prosecutor may or may not act objectively. Independent civil actions serve as a safeguard against the potential inaction of the prosecutor. Kung sasabihin ng prosecutor na walang liability ang ating kapulisan, wala na tayong magagawa. Tatanggapin na lang natin iyon. However, because of the independent civil actions, we are now free to come to court on our own terms, to hold people responsible regardless of the conclusions drawn by our prosecutors. The quantum of proof is also more relaxed. Pwede tayong maghabla kahit hindi kumikilos ang prosecutor because the criminal case and the civil case exist on two separate parallel realities. The conviction or acquittal of the accused has no bearing on our right to come to court and demand damages. Kung ikaw kapatid ay nagmamadali dahil late ka na sa klase o ito lang talaga ang oras mo sa review, then you can stop here. For the rest of us, I would like to continue and discuss specific instances that fall under Article 33 of the Civil Code. When the law mentions defamation, it should be taken to mean on its face value, in the ordinary meaning of the word. Ganyan siya ipapaliwanag sa inyong klase kapatid at maaaring okay na doon si judge o si ma'am. Sa kanilang pananaw ay binasa nyo naman yan at naiintindihan nyo naman. For the rest of us mere mortals in the law, defamation here comes from the Spanish word defamación, which translates to libel in English. Defamation kapatid is the imputation of a crime, vice, or defect, real or imaginary, or even any act or omission, status, or circumstance. This imputation must be directed upon another person publicly and with the intention to dishonor, discredit, or in contempt of the person so defamed. Ang defamation na tinutukoy sa Article 33 kapatid ay umbrella term ng mga krimen na napapailalim sa Title 13 ng Revised Penal Code. Ito ay ang paninirang puri sa isang tao, opisina, ahensya o korporasyon sa pamamagitan ng pagbibintang ng isang krimen o tahasang pangiinsulto na siya namang ikakasira ng pangalan ng isa pang tao. Defamation is punished kapatid because the law treats our reputations on the same level as our lives, our liberty, and our property. Kung tatawagin nating estafador ang isang negosyante, totoo man o hindi, maaaring hindi na siya pautangin ng ating mga bangko. One of the most important elements of defamation is that there must be an imputation. Pasok sa defamation ang sabihin na ang isang tao ay magnanakaw, estafador, o walang mabuting gawa. Pasok din dito ang physical attributes, peke ang dede niya, o wala siyang ilong. Pasok din ang kanyang personal circumstances or status, gaya ng anak siya sa labas, o ang 6 niyang anak ay lahat panganay dahil malandi siya. This imputation, this insult, kapatid, must be with the intent to injure another person. It must be made in bad faith. Bad faith or malice is a condition of the mind. It is very difficult to prove in court, and that is why the law creates for us the presumption that every act of defamation was made either in bad faith or with the intention to cause injury. This rule will not apply when 1. The communication is made privately in the performance of any legal, moral, or social duty. 2. The communication is a fair and true report made in good faith, involving judicial, legislative, or other official proceedings that are not confidential in nature. Defamation must be directed at another person. This person can be a natural person like you and me, or it can be an artificial person like a partnership, a corporation, or a government agency. Kung sa pamilya ng mga De La Cruz ay 6 silang abogado at sinigaw mo kapatid na magnanakaw yung attorney De La Cruz, then you have committed only one single act of defamation. Please remember that. Defamation must also be made publicly. It can be in the presence and hearing of other people, plus the person against whom you have made the malicious imputation. It can be through a newspaper, a vlog, or through graphics you have posted online. All that the law requires is the imputation reaches someone else other than just the person you have just insulted. Finally, the imputation must tend to cause the dishonor, discredit, or the contempt of the person so defamed. This is probably the most difficult element to prove when it comes to cases of defamation. Kailangang mapatunayan natin, kapatid, na nasira nga ang pangalan ng taong ininsulto. Kung sasabihin ng isang news agency na convicted sa kasong plunder si Senator X, then they are not committing libel because they merely reported a factual matter. The Sandigan Bayan made a decision and they are merely relaying to the public that Senator X was convicted of the crime of plunder. Kung sasabihin ng isang news agency na magnanakaw si Senator X, then they would be changing the tenor of the reporting. The liability extends to the writer, the editor, and the publisher. They are no longer relaying the decision of the Sandigan Bayan. Instead, they are now commenting on the case. Kung sinabi ng isang news agency na tinawag ni Senator Y na walang silbi si Senator X during one of their sessions in the Senate, then the news agency would not be liable for defamation. It was a fair reporting of something that happened in an official government proceeding that is not confidential in nature. However, there would be defamation on the part of the news agency kung sakaling sinabi nilang walang silbi si Senator X dahil lagi siyang late, absent at puro sausaw lang sa mga proposals ng ibang senador, all on the basis of the mere statement of Senator Y. I hope I am making sense, kapatid. Sana nasusundan mo kung saan o paano nagkakaroon ng defamation. If I am making sense, kapatid, please pause this video and type following in the comments down below. Kung hindi naman, magtanong ka lang kung saan malabo, kapatid, at sasagutin ko. Now let's talk about fraud, panloloko. In the case of Tsuneshi Heavy Industries versus MIS Maritime Corporation, the Supreme Court, speaking through Justice Hardeleza, gives us the definition of fraud. Fraud is defined as the voluntary execution of a wrongful act or willful omission while knowing and intending the effects that naturally and necessarily arise from that act or omission. In its general sense, fraud is deemed to comprise anything calculated to deceive, including all acts and omission and concealment involving a breach of legal or equitable duty, trust, or confidence justly reposed, resulting in damage to or undue advantage over another. Fraud is also described as embracing all multifarious means that human ingenuity can devise and is resorted to for the purpose of securing an advantage over another by false suggestions or by suppression of truth. And it includes all surprise, trick, cunning, dissembling, or any other unfair way by which another is cheated. This is a very short case and I encourage you to read it. It might or might not be asked in our quiz later. I have chosen this case because the definition of fraud is applicable not only in civil cases, but it's also the kind of fraud that's discussed heavily in civil procedure. Mula sa definition na ito, kapatid, we know that the following are the elements of fraud. 1. The execution of the act must be voluntary. 2. The act must be done with knowledge and intention. 2. The act must involve some deception. 4. The act must result in damage or undue advantage over another. When Article 33 of the Civil Code talks about fraud, it covers all of the crimes embraced under Chapter 6 of Title 10 of the Revised Penal Code. It may also involve other crimes punished elsewhere in our special laws such as credit card fraud. Sa ilalim ng fraud, kapatid, ang taong nanloko ay nanloko nang alam niya ang magiging resulta ng kanyang panloloko. Nanloko din siya dahil ginusto niya, hindi lang dahil sa aksidente. Lahat ng uri ng scam o panloloko ay covered dahil likas na malikhain ng mga Pilipino. May bago at bagong scam na lumalabas. Finally, and I feel this is the most important, ang panloloko ay dapat naisahan, meaning there must be some form of damage, injury, or undue advantage. Sa palabas na Suits, hindi abogado si Mike Ross. Pumasok siya sa law office voluntarily. Hindi siya kinaladkad ng kung sinong tao para magtrabaho siya bilang abogado. Alam ni Mike Ross at ni Harvey Specter na hindi ito abogado, pero tinuloy pa rin nila. Maraming tao ang naloko nila, and the damage or undue advantage you will later see as you watch seasons 1 and 2. When the law talks of fraud, there are two kinds. The first is fraud in factum or fraud in esse. It is the fraud in the performance of an obligation. The second is fraud in inducement, or that fraud that was used in obtaining someone's consent. Halimbawa kapatid, fraud in factum or fraud in esse na maituturing kung jumowa ka ng isang lalaki na nakilala mo online na siya raw ay seaman at tutulungan kanya sa law school. Dahil sa iyong karupukan ay pumatol ka sa kanya nang makuha na niya ang kanyang inaasam na pansit canton with egg at 3 a.m. in the morning, hindi na siya muling nagparamdam sa'yo na isahan ka kapatid during or in the course of your relationship. Fraud in inducement naman kapatid, kung siya ay nagpakilalang 6-footer at matangos ang ilong, matipuno ang pangangatawan. Ginawa mo siya pero noong kayo ay nagkita ay kaya pala siyang mabox out ni Kim Chu. Naisahan ka kapatid when he was obtaining your consent or prior to the commencement of the relationship. Elsewhere in the law under civil procedure, there are also two kinds of fraud. That's extrinsic fraud and intrinsic fraud. Extrinsic fraud refers to any fraudulent act of the successful party in a litigation which is committed outside the trial of a case against the defeated party or his agents, attorneys, or witnesses, whereby said defeated party is prevented from presenting fully and fairly his side of the case. Intrinsic fraud, on the other hand, refers to acts of a party in a litigation during the trial, such as the use of forged instruments or perjured testimony. Classic na halimbawa pagdating sa extrinsic fraud, ang pakikipagkuntsaba ng isang abogado sa sheriff o process server ng isang korte, kung saan palalabasin nila na na-serve ang summons, pleadings, or motions sa defendant, ay ito naman pala ay napapadala sa isang peking address. Sa ilalim ng extrinsic fraud, ang fraud ay dapat mangyari sa labas ng trial at ang resulta ay loss of the opportunity to present and defend a case. On the other hand, mas madaling unawain ang intrinsic fraud. This is fraud within the course of the trial. Maaring maglabas ang isang abogado ng mga dokumento kung saan na doktor lang ang pirma ng isang tao o mag-present ng peking credentials ng isang witness. Finally, we have physical injuries. Physical injuries as applied in Article 33 does not only cover the crime of physical injuries in Chapter 2 of Title 8 of the Revised Penal Code. Physical injuries here refers to the ordinary meaning of the phrase. So long as there is bodily harm, pasok ang mga yan sa Article 33. Physical injuries here includes murder, homicide, parricide, infanticide, and mutilation. The stage of execution here is also not important. It does not matter whether the murder was consummated, frustrated, or attempted. The phrase physical injuries is used in its generic or ordinary sense. There is, however, one notable exception, and that is criminal negligence. Criminal negligence is punished under Article 346 of the Revised Penal Code. Criminal negligence is committed either through simple imprudence or reckless imprudence. There is simple imprudence when there is a lack of precaution, kakulangan sa pag-iingat, but the impending damage is not immediate or the danger is not very clear. Simple imprudence also requires that the act done was done without malice, bad faith, or no intention to cause harm or injury. Reckless imprudence, on the other hand, requires that there must be some voluntary act, but this act was done without malice or the intention to cause harm. The act or the failure to perform an act must be the result of an inexcusable lack of precaution. The recklessness of the act is evaluated based on the offender's employment or occupation, degree of intelligence, physical condition, and other circumstances regarding persons, time, and place. Mas madali nating maiintindihan ang kanilang kaibahan kung magbibigay siguro tayo ng example. For example, here is A. Siya ay nagmamaneho isang gabi sa gitna ng isang bagyo sa isang liblib na kalsada. Your instincts, kapatid, will tell you to slow down, drive carefully, at makakauwi ka rin. Kunwari out of nowhere may biglang tumawid sa kalsada. Hindi siya nakita ni A dahil sa ulan at walang ilaw ng mga poste ng kuryente. Naiwasan man siya ni A ay tumama pa rin ang pedestrian sa kanyang side mirror. Here, A is liable only for simple imprudence resulting to physical injuries. The answer would be different if A was a police officer who was still on duty. Before he drove home, A had a drinking spree with his brother-in-law. Habang sila ay nagpapatila ng ulan, bumuhos ang ulan at ginabi na si A. Sa takot niya sa kanyang asawa o sa girlfriend niya, ay binilisan niya ang pagmamaneho. Hindi niya nakita na may biglang tumatawid. Tinamaan niya ang pedestrian at napuruhan niya. Pero buhay pa rin ang ating pedestrian. Despite the heavy rains, the isolated road and the darkness of the night, A drove at speed while under the influence of alcohol. Here, A would be liable for reckless imprudence resulting to physical injuries. If there's one thing you should remember from this discussion, kapatid, it is this. The reason why reckless or simple imprudence is excluded from Article 33 is because all of the three acts mentioned here, defamation, fraud, and physical injuries, all of these require malice. The defamation, the fraud, and the physical injuries must all be committed with the intention to cause injury or damage. Reckless or simple imprudence is still an independent civil action. The basis, however, is under Article 2176 of the Civil Code. Sa ilalim ng Article 33, kapatid, ang paninira ng puri, ang panluloko at ang physical injury gaya ng murder, lahat yan ay sinasadya. Lahat yan ay ginawa para manakit ng kapwa-tao. Hindi yan nangyayari dahil lang sa aksidente, lahat yan ay sinasadya. Earlier in this discussion, I have mentioned that independent civil actions exist in parallel realities alongside the criminal action. Halimbawa, for the crime of libel, the independent civil action is Article 33, specifically defamation. Kung sa kasong estafa, the independent civil action is fraud. Sa kasong murder, ang independent civil action mo dito ay Article 33, specifically physical injuries. Kung ang criminal case, kapatid, ay sa ilalim ng Article 365 ng Revised Penal Code, ang independent civil action niya ay Article 2176 ng Civil Code. That's the way it was taught to us. Titignan natin kung sinadya o aksidente lang. Pag aksidente lang, ang gagamitin natin ay Article 2176 at ang partner niya ay Article 365 ng Revised Penal Code. Going back to Article 33 of the Civil Code, the law tells us that an independent civil action may be brought to court on the basis of defamation, fraud, or physical injuries. The quantum of proof here is going to be mere preponderance of evidence. Finally, the civil case for damages under this provision will not be affected in any way by the results of the criminal action. To summarize tonight's lesson number 1, Article 33 of the Civil Code provides an independent civil action for defamation, fraud, and physical injuries. Defamation covers criminal offenses such as libel, slander, and cyber libel. Fraud here includes estafa and credit card fraud. Physical injuries covers all forms of bodily harm except those committed by reckless or simple imprudence. 2. The basis of the independent civil actions under Article 33 is the presence of malice or the intention to cause injury or harm. 3. The independent civil actions under Article 33 are also bound by the same prohibition against double recovery. A reservation to file a separate civil action during the prosecution is not required. That's it, kapatid. I hope you learned something new tonight. Alam kong paspas ka ngayon sa paghahanda mo sa darating na pasukan at gusto ko ring tulungan kita. This Sunday, August 15, 2021 at 1 o'clock p.m., we will be holding batch 3 of our mock online class. Magbibigay ako ng reading assignment at least 24 hours before the class. And you will be asked to do your own research, read the materials I've assigned, and come to class ready to recite. During the class, I will call on you to recite and then I will give you a grade and feedback. Malaking tulong ang mock online class para yung matikman, kapatid, ang buhay natin sa law school. Mararanasan mo kung anong feeling ng matawag sa klase, matanong at hopefully makasagot. Nang sa gayon ay kapag tinawag ka na sa klase mo ay hindi ka nakakabahan. Alam mo na ang pakiramdam. Fair warning kapatid, during these mock classes, I am not my usual calm and polite self. This is to simulate how you would react to our terror professors. If you are interested in signing up for our mock online class batch 3, then please sign up using the link in the description down below. Finally, there is a short quiz for us to test how much of the material you have actually understood. Please post your scores because I find joy whenever I see some improvement in your performance. If you would like us to continue with lessons on Intro to Persons, then please let me know by typing yes in the comments down below. Thank you so much for watching. Like and share this video for good law school karma, and I will see you next Friday.